Hello, this is Jay. This is Jay Carpenter of the Phone Word Forum. Today is Wednesday, July the 25th, 2012, at approximately 4 p.m. Eastern Time. Today's Phone Word Forum is on FCC action recently regarding toll-free number brokering fine of $240,000. And today's guest is Robert Keller. Bob's an attorney who's been a long-time specialist in this field and has circulated some comments on this recent action, which were sent out. I sent out the comments, I believe, July the 12th. So we're going to have basically an open conversation today, and I'm sure some other folks will be joining us. Is there anything anyone would particularly like to cover or, say before we really get started today?
I just want to introduce myself. It's Bill Sharp with Sharp Investments.
Hi, Bill.
Hello.
Thank you for introducing yourself. Anybody else like to say, announce who they are?
Sir, Greg Fernandez here with THE Telco.
Thanks, Greg.
In beautiful Southern California.
All right.
Who else is on?
I'm envious. Go ahead.
Tom Mogul, MBZ Communications.
Hi, Tom.
Hey, Tom.
How are you, gentlemen?
Good. Anyone else?
Wow.
Well, it's one after. I'm in kind of a noisy environment today, and so I'm gonna mute myself. Why don't we go ahead and get started? I'm sure some other people will chime in. Hello?
Hi, it's David Greenhouse.
Hi, David. Welcome.
Hi, Jay. How you doing?
Very well. So I think we're going to go ahead and get started. I'm sure some other people will join us, but I'm going to go ahead and turn it over to Bob. I've known Bob for, wow, I think since I first got in the business or shortly thereafter, which is going on like 20 years now. So Bob has studied and specialized in the toll-free arena and telecommunications for a number of years, and I definitely respect Bob's opinion and analysis. Bob was also part of the toll-free summit in San Diego, which was April of 2011. So, Bob, I'll go ahead and turn it over to you, and you can talk about the recent action, and we'll open it up for a discussion after that.
Sure. Well, thanks, Jay, and thanks for asking me on here. I hope it hasn't been 20 years. It doesn't seem it's been a while, though. Well, in some ways, this is a rather routine, typical order of this type for the FCC, and in other ways, it's pretty significant for those in this industry. For those of you who haven't read it, or at least haven't read a summary of it, the long and the short of it is, back in 2007, the FCC issued a citation against Richard Jackowitz for allegedly having, violated the anti-brokering rules by trying to sell toll-free numbers. At that time, as the FCC interpreted under its rules, there's only certain types of people that can, right off the bat issue a fine against. I mean, you have to be either a broadcaster or a regulated common carrier, like a telecommunications carrier, like a telephone company or cellular, or doing certain other activities. If you don't fall into one of those categories, they can't fine you until they first issue a citation. And then if after that you violate the rules again, then they can fine you. Well, they issued a citation against him for this alleged conduct in 2007. And then on July of this year, all of a sudden what hits the releases is this order assessing a $240,000 forfeiture, and that's the FCC's fancy word for a fine, if you will, for having done it allegedly again. And I'm only going by what the facts are stated in this order. I mean, I've not talked to him. I don't know the other side of the story, but taking the facts as they're stated in the order, you know, apparently he had a number which Bristol Myers, the pharmaceutical company, was interested in. They found out that they contacted him about it. He apparently, according to this order, offered to sell it to them. Not only that, but several other toll-free numbers that also happened to coincide with various Bristol Myers trademarks. And I guess Bristol Myers at one point or another decided rather than to negotiate a deal, they went to the FCC and complained. And after evaluating everything, the FCC assessed a $240,000 forfeiture, saying that this conduct violated the prohibition on brokering toll-free numbers, which includes, you know, trying to sell them, of course. That's the long and the short of it. And as I say, on one hand, it's rather unremarkable because that all sort of turns on whether the facts are accurate as they stated them or whether there's another side of the story that he's going to try to tell in challenging this. But I think it's significant for us for two reasons. One is the sheer size of it. There have been a lot of different enforcement actions, but this is the first time that you know, a significant, any fine as far as I can recall, but a significant fine has been assessed, and that, you know, $240,000 can sort of hurt your feelings in terms of you know, your business opportunities or business expense. But the more important reason, though, is that over the past several years, we've been piling up a number of precedents in this area, and I don't think they're necessarily good for us. And part of the problem is the cases that actually get to the FCC to get decided like this are not necessarily the best possible cases. I mean, usually the FCC's Enforcement Bureau does not get involved if everything is going properly or everything is, even if everything is sort of, well, maybe questionable that we don't know. They tend to only deal with the cases that, you know, are sort of over the top. And unfortunately, those are the cases that set the precedent that then sort of hems us in further in other areas. I mean, I already mentioned there was the Jackowitz situation back in 2007 where they first issued the citation. About a year ago, or actually it was right around the time of the San Diego summit, the FCC issued a citation against Bill Quimby. Now, technically the citation was for having failed to respond to FCC inquiries, but it was clear underlying the inquiries they were questioning him about brokerage type things. There have been other sorts of cases going back even back before the second report and order when the brokering rules were adopted on various aspects of this. And I'm just concerned that as more and more and more precedents line up like this, it's going to sort of set the bar pretty high in terms of what you can do with transactions that are kosher, or that at least won't attract attention and cause trouble. And the problem that I see is that the FCC, certainly in its language, but a lot of us tend to focus on the anti-brokering provision. In other words, the prohibition on selling numbers. And that's true. That provision is there. But to keep in mind, that is only part of the deal. The anti-brokering rules formally only came in with the second report and order back in, I don't know, I think that was around 96, 95, 96, something like that. But
Bob,
the
I
policy,
think that was 1997.
97, okay. The policies underlying this go before that. That sounds about right. The policies underlying this go before that, and those were the whole adoption of the portability concept, the setting up of the SMS 800 database, and certainly there was this concept of anti-brokering, or at least that you didn't quote-unquote own the phone numbers. But what was really underlying it, and what's really the driving force behind it, was this concern about having true number portability and first come, first serve. And probably more important than the Jackowitz case is a case back in February of 2011, Transaction Network Services, where there had been a lawsuit between as I gather, it was some sort of a credit card or financial clearinghouse company and a customer. At any rate, in the course of the lawsuit, there was sort of a arbitration, and one of the things the arbiter did in that case was directed the defendant to turn over 3 of the toll-free numbers to the plaintiff. And so the defendant went to the FCC and sought a declaratory ruling, and the FCC said, well, no, a court can't do that. Only the FCC can authorize, a transfer of numbers like that. But in the process of so doing, they stated out loud and very clearly, unequivocally, what has always been on the books, and that is that a REST board is not allowed to transfer a toll-free number directly from one user to another, period. They didn't make any exceptions to that. They didn't make any caveats to that. And in fact, if you read the rules literally, there are none. So whether you're buying or selling for a profit or not, in the FCC's view, and the way it's written on the books and in the tariff, any transfer of a toll-free number from one user to another without it going back into the spare pool is prohibited. And I think, as we all know, whatever your view on that concept generally is, that applied as a strict rule is sort of unworkable. And this is the concern. And so in that sense, this Jackowitz order is just the latest in a whole series of enforcement-type actions and other FCC rulings in this area. And I think the $240,000 fine, while that's a hefty number, and that's sort of creates a lot of excitement, that's not the real crux of the matter, because it wouldn't matter. It wouldn't matter whether it was any fine at all. That precedent is one that's a problem that is going to have to be addressed at some point. So let me stop and take a breath there in case, I don't know if anybody wants to, I have some more to say down the road, but I'll just stop there for a moment because, Jay, I don't know how these things work, so I'll let you direct it from here.
Yeah, would anyone like to make some comments or questions based upon what Bob just detailed?
Well,
Bob, I'd like.
Go ahead.
Good. This is Jay. I'd like to just note, I was taken aback by the February 24th, 2011 ruling by the FCC on this arbitration case. I did not realize that the FCC had the power to override binding arbitration to federal district court rulings, and then I'm not sure if it went to appeals or not, but I think there was a pending appellate level action that was basically just overruled. So,
well, yeah, let me say a couple of things about that. That's the name of the case is Transaction Network Services. In the FCC, I don't know where the state proceeding stands, the arbitration proceeding, but the FCC proceeding, the declaratory ruling that they issued there, I believe the other side did file a petition for reconsideration, and as far as I know, that remains pending at the FCC right now. The FCC, I know it can be confusing to, I think, to be half facetious, maybe lawyers make things confusing on purpose, but the FCC doesn't exactly have the power to overrule a state court or an arbitration, but what the FCC does have is what is sometimes referred to as primary jurisdiction, that in certain areas where federal law, Congress has set up, the FCC has regulatory authority over certain areas, then in those areas, the court, a state court and state laws can't override it. And in this case, the only aspect of the arbitration order that the FCC affected was the specific direction that the numbers be turned over. The FCC did not weigh in on the accurateness of the ruling and making a judgment for the defendant or in any other remedies applied, but insofar as part of the remedy was the direct transfer of those numbers, the FCC simply weighed in there and said, not that we're overruling it, but they basically said the court and the arbitrator did not have the jurisdiction to do that. Only the FCC can authorize that. That's what the basis of the ruling is. In that particular case, by the way, I think it's a two-edged sword. I think that case is both bad and good. The bad aspect, and of course depends on your point of view, but my point of view is one where I deal with a lot of clients who have reasons to do legitimate, needed commercial transactions that arguably involve direct transfers of toll-free numbers, and therefore, there's a concern here. What's the legality? And so the bad aspect of the case is that the FCC came out and very unequivocally said Westborgs may not directly transfer numbers, period. They didn't make any exceptions. They didn't caveat it in any way. But before we get too excited about that, let me say that there's arguably a good aspect of the case. And one of the reasons I advocated against challenging this ruling, because some people wanted to, and that is, if the case had gone the other way, I don't think any of us necessarily want to be in a situation or in a world where any state court or any arbitrator, you do a transaction with a number, and now somebody's unsatisfied, so they go and sue in court, where any court or any agency can basically, given the right proof, can say, we order your number, we order you to give your number back, or to give your number to X, Y, and Z. We order you to transfer your number to, party X. And what can you do? Well, at least with this FCC ruling, that's not litigation. State court, civil law litigation, even federal court litigation for that matter, is not an avenue that one can pursue with the hopes of getting a remedy that's going to require you to transfer a number to somebody else. So that aspect of the case is good, but what is a negative aspect of the case is this idea that you can't directly transfer numbers. Now, they did. I misstated slightly. I said they didn't allow any exceptions. There is one exception, and that is when the FCC authorizes it. The FCC itself can authorize exceptions in specific cases, and I'm sure you're all familiar that they did so in the case of 800 Red Cross and the 800 suicide, and there may be a couple of other less visible instances out there. Now, and that's always a possibility. It's not a road I don't think many of us want to go down. But I mean, if you wanted to be 100% kosher without a question, what you would do is go to the FCC in advance and say, "Can I do this transaction?" And quite frankly, there were a couple of requests filed with the FCC doing just that. I don't know that they've ever been ruled on. But the problem with that is, if you ask a question, then you either get no answer, in which case then what do, or you get an answer you don't like, in which case you're sort of at a loss at that point. So yeah, that's the transaction network cases, and that's the primary one that has sort of lit the fire for me, saying we need to address this issue. Otherwise, we're always going to be in this area of uncertainty. Every time I do a transaction, is it legal? Is it not? And, I as a lawyer can't give a 100% clean opinion on something that involves a direct transfer of numbers. All I can do is do my best to structure the transaction in a way that is arguably kosher and has the best possible chance of succeeding if it's challenged. But that's not always good enough. I mean, I'd rather have a situation where the FCC's regulations and policies recognized reality and reasonableness.
This is Jay Greenhouse.
Hi.
I was thinking one thing that hasn't been mentioned is right after the Transaction Network Services decision came out, or a little while after that, having read it, the individuals in SNAC read it and realized that that the way it was written was really going to tie their hands in every situation of a transfer of a number, and specifically for things that didn't even involve any kind of a transaction necessarily. So we set out to contact the FCC and said, there's some just really good exceptions to this rule that happen all the time, that are necessary to our businesses, and we gave them a presentation of 4 or 5 what we thought were necessary exceptions. They came back to us wanting more information along the lines of how would these be implemented, how would they be enforced. We came back to them with something in writing, and we're talking about things like if you sell a business. If you sell a business, it has phone numbers along with the business. Those numbers really need to go along with the sale of the business. If you mistakenly lose a number into the pool that was, let's say, the fault of the risk board, and the subscriber wants to get that number back. It may be that somebody else picked it up, but it really belongs to that original subscriber. A mistake has been made. So there's 1 or 2 others that we thought were like where we weren't talking about buying and selling telephone numbers, but we were talking about the usual case of doing business in toll-free, and things that just had to, that been sort of pretty obvious exceptions to the rule. And in fact have been status quo for a long time. We still have not. We've been told that they're going to rule on those exceptions, or at least comment on them, but it's been quite a while and we haven't heard a thing.
Well, thank you for that. You actually. I'm sorry, were you finished? I didn't mean to cut you off. Thank you. Yeah, well, I was going to say thank you for bringing that up. You actually stole my thunder. That was one of the things on my list to talk about. And, in fact, there were several meetings by different parties raising this kind of question with the FCC sort of informally in meetings. The only reason, you know about that is they have to file these sort of ex parte memorandum afterwards to get put in the record. But the item that you're really referring to is in August of 2011, Addis, the sort of arm that is SNAC. I get confused with how the whole relationship works, but the industry group, Addis, filed a petition for rulemaking, a formal petition for rulemaking with the Commission on this very issue. There have been precious few formal comments filed on it. I think partly because the Addis members already represent most of the big carriers, and in terms of they're participants of the organization, and maybe they didn't want to directly weigh in. But there were 1 or 2 other comments that were filed in support of the rulemaking. I don't recall I saw anything contrary, arguing against the rulemaking proposal. In fact, what I would advocate is that this is the perfect vehicle for people in this industry to use, is to latch onto this and to come in and file comments either in support of this or saying you support it, but maybe with slight modifications. But before I get into that, I've got it in front of me here, and let me just tell you what they specifically said. I'm just going to read one paragraph from the rulemaking petition. It said, Addis acknowledges the policy underlying the Commission's toll-free number rules. However, in some specific circumstances, this policy would be better served through a limited exception to these rules. Addis has previously identified 3 categories of direct transfer of toll-free numbers that do not implicate the efficiency and depletion concerns that animate the Commission's rules governing the administration and the shared toll-free number resource. Those include ones which, and here are the 3 exceptions they would write. 1, toll-free numbers are mistakenly returned to the spare pool and picked up by other carriers. 2, there are fraudulent or unauthorized transfers of shared use numbers. Or 3, there are legitimate mergers, acquisitions, bankruptcies, and other business transfers that necessitate transfer of the toll-free numbers. Now, they go on to say that in each of those cases, allowing the direct transfer would be a good thing in the public interest and wouldn't undermine the FCC's policies. And I'm not exactly sure how you interpret the first when toll-free numbers are mistakenly returned to the pool and picked up by other carriers. I mean, the devil's in the details there. I might agree with that. I might disagree with it, depending on what that actually means. But the other two, certainly, the idea of you should be allowed to do a direct transfer of a number to remedy a fraudulent transaction. And then the last one is the one where I think we live and breathe. There are legitimate mergers, acquisition, bankruptcies, and other business transactions that necessitate the transfer of toll-free numbers. Not many people are out there just blatantly marketing the sale of bare telephone numbers, and even fewer would actually admit it or defend it, even if they were. But all of us have all sorts of business transactions that we engage in every day that would fit this definition. You know, it's a legitimate business transaction. Another way I always like to say it is something where the transfer of the toll-free number is just ancillary to an otherwise larger business transaction, whether that involves the sale of a business, whether that involves a resolution of some intellectual property, trademark issues, whether it involves a marketing and branding plan where, you know, you have all sorts of assets, which include domain names, trademarks, service marks, advertising copy, and also the toll-free number that sort of corresponds to that. I mean, there's any number of situations, but technically, and Addis is right, the way the rules read right now, if I'm a sole proprietorship, has a toll-free number and I die, technically, the estate can't transfer the number to my heirs, if you want to get technical about it. Now, I don't think the FCC ever intended that. As I was mentioning to Jay on a phone call earlier this week, or might have been earlier today, the FCC has a toll-free number, 1-888-CALL-FCC. I'd be willing to bet a few mortgage payments that did not come first served directly out of the spare pool. So, I mean, obviously a rule of reason needs to apply here, and I think this Addis rulemaking is a way to do it, and the advantage to sort of getting on that bandwagon. Yes, this was August 2011. That's almost a year ago, and nothing's happened, but that's FCC time. Things move slowly. And if you were starting from scratch right now, you could expect to sit around another year waiting for an answer to whatever you came in with. But if people come in now, we come in response to this Addis ruling that's already been there, and just say, yeah, this is a good idea for these reasons. Please move forward with this. I think it has a better chance of some short-term action, some action sometime in the very near future. Now, what that action would be, by the way, is probably a petition for rulemaking. In other words, you're not going to come out in response to a petition for rulemaking. They are not probably, very unlikely that they're, in fact, I'm almost guarantee you they wouldn't just out and out modify the rule. What they will have to do under the Administrative Procedure Act is first issue a notice of proposed rulemaking, then get comments from the wider public, and then after considering those comments would then modify the rules. Anyway, I'll shut up again for anybody to comment or question.
Yeah, thank you, Bob. This is Jay, and just to add a little historical perspective, I believe there were a whole number of similar type rulemaking petitions that started, I don't know, maybe back in the mid-90s. And basically in one wave of the hand, I can't remember what year it was, I want to say 2007 or something like that, you know, those rulemaking requests that had been submitted were just dismissed. So, you know. Hey, Aaliyah.
Hi.
So, you know, I concur with Bob. I think commenting on the Addis action is certainly something that is actionable, you know, right now. And I think that, you know, resubmitting requests for rulemaking, you know, with a set of examples and circumstances and so forth, would be appropriate, even though, as and maybe Greenhouse, like, you can help me out with this, but it seems to me that when all those pending actions were dismissed, I believe you and I had a call with the FCC, and they said that, they would be willing to look at it again if there was some sort of substantive change that had occurred. Is that your recollection?
Were you asking me?
I was asking David Greenhouse, but maybe he's not on the call.
I don't know.
So,
but I don't know that was. I think we talked to them at a Nancy meeting and got that.
That might have been it.
And that they said, if something new comes up or something that we haven't considered in the past that bears consideration, that is reason enough to open it up again. And I've since had conversations. I'm on the Nancy, and I go to meetings every 3 months, and usually try to touch base with the FCC people and see where this is at, and whether they're getting closer to coming out with some sort of decision or a NPRM or whatever. And they assure me that it's up there on their agenda. And they also, I normally ask them, have they given any consideration to the white paper that came out from the Nancy, and they still have that. They still they know what's in it, and they consider it a separate issue, but one that they would consider opening for further discussion. But that again, by FCC times, that could be years from now.
My take on what went down here, and I don't know if this is related to the rulemaking petitions. I'm not aware of formal rulemaking petitions, but I am aware of a lot of pleadings and comments and things like that were filed going back to about 2000. What you all will probably recall, what happened in December of 2000 was when the FCC sent a letter to Michael Wade of Disney directing that Disney do something with the SMS database in the system, the technical system, to make it impossible to do such transfers. And immediately AT&T came in, filed a petition for declaratory ruling, basically saying, this is going to be a problem, and a lot of other people in the industry weighed in, and then tons of paper and meetings and things like that were had with the FCC, and the FCC on multiple occasions extended that deadline until finally in early 2002, I think it was I don't remember, probably in June of 2002, something like that, the middle part of the year, they had a quote-unquote forum where various members of the industry came in and sort of said their piece. This was not a formal hearing. It was just a forum where things were publicly expressed. Not just about that, but that was a major focus. And then ever since then, the thing just died. The FCC never, as far as I could tell, ever again formally, they extended the deadline several times and then just went silent. So technically the deadline came and went. Nothing ever happened, and business went on as usual. And I think everybody was sort of content to sort of let things lie, figuring that, nobody's going to be ridiculous. The FCC isn't going to be ridiculous and nail us for a legitimate, necessary transaction.
Right.
But then along comes Transaction Network Services, and then that created a problem, and now it's heated up again.
Right. Bob, this is Jay, and I was at that forum and actually submitted a paper that was co-written by Mitch Kniesbacher. And then there was a forum in 2004 whereby, and I can't remember if it was 2002 or 2004, but one of the economists from the FCC, a fellow named Les Seltzer, actually did a PowerPoint presentation advocating a market-based allocation method for toll-free numbers. And he enumerated, all the points that we're talking about today. And unfortunately, I guess he retired. But there are compelling business, functional, technical reasons to have a transfer process, market-based or otherwise. I contend that the market is the best mechanism to effectuate the transfer because toll-free numbers are not fungible. They're not like IP addresses where everyone's the same as the next. Toll-free numbers have differentiating characters and qualities that alter their usability and marketability and value in the marketplace and the results that you get. I mean, even if you look at repeating numbers, forget about the vanity portion, but repeaters are more effective in a marketing campaign than a number that's has some sequence that's impossible to remember or difficult to remember.
Right.
So, and certainly, in the white paper, I think it was in the white paper, we brought up the Australian model, which has worked very well since 2004. And in fact, in a call on the PhoneWord Forum in December, I think it was, where we had the regulators from Australia, they're actually looking at, or they are interested in opening up the market-based allocation to their equivalent of geographic numbers. So it's been very successful down in Australia, and as time goes on, I think there's a growing use case in North America for something similar to be instituted. So, my hope out of this call would be that there is a growing conversation among the toll-free industry.
Sure. Let me just also throw out one thing too, though. I've advocated too already that people should consider following up on the already pending Addis petition for rulemaking. And you're now talking about a market system. Either you or somebody else mentioned a while ago, maybe having other conditions that ought to apply, et cetera. And I don't disagree or agree either way on any of that. I mean, I think there's a case that can be made for sort of a total open market that says that the FCC shouldn't even worry about pure, crass monetary transfers of numbers, just the numbers themselves. I think a good economic, legal, and other argument can be made in support of that. However, as a practical matter, that's going to be a hard sell up front. But what I was really going to say is that what I would suggest that people do, if you do decide to do some comments on this pending petition for rulemaking, something along the way of simply noting to the Commission that you're aware this is there, you think it's a good idea, and that the FCC should move forward with it because this is important to the industry. I would not advocate commenting, especially not sort of different comments or different ideas, the specifics of the Addis proposal. In other words, I wouldn't go in and say, well, we agree with this, but we think it ought to be these 5 things. Or, like I said, I don't really know what number 1 means, and I would have concerns depending on how that's interpreted. But I wouldn't say that in these comments. I would simply say that while I don't take a position on the specifics of this, I think this rulemaking petition is good, and I think you should pursue it. And here's my reason. If we come in with lots of different ideas that go beyond the specific ideas laid out by Addis, then that's going to get chewed around for another year. Nothing's going to happen. On the other hand, even if they go forward with this proposal by Addis, as I said, what they're going to do is a petition for, a notice of proposed rulemaking. The response to a petition for rulemaking is either to dismiss it with the brush of the hand, as you commented happened before, or to issue a notice of proposed rulemaking, which begins a formal rulemaking process. In that formal rulemaking process, you will then have opportunities to come in with all the specific kinds of ideas that you would like to have considered. But if we bring those up, I think the first order of business right now ought to be to use the vehicle of the pending addis petition just to get them to start the rulemaking process. And getting into specifics with them right now would probably slow that down. And you're not losing anything because it would be fair game in a notice of proposed rulemaking to say, well, I like points 2 and 3, but I don't like 1. And by the way, I think there should also be points 4 and 5. That's stuff you can always say in comments on the rulemaking.
Okay, and I suppose, Bob, that it would support Addis's case if there were more comments submitted from the industry.
Well, yeah, more comments, or people can group together and do them, or however. But I mean, the idea is to get this process off the ground, and once there's a formal petition for rulemaking, once there's a formal notice of rulemaking out on this, then everybody can move into gear and do all the things that one does: prepare comments, plan on having meetings with commissioners, going and finding out who's in the Office of Engineering and Technology or Science and Technology these days. You mentioned an economist who was there, Seltzer, at the time, because I believe there is an economic analysis that can be done to show that the FCC's concerns about efficiency and number depletion are not adversely affected by these kinds of transactions. So there's all sorts of things that we can offer once that process gets going. But yes, right now I think the more people that come in and say, I'm only aware of one formal thing. I've got it in front of me, and I probably knew what this was at the time, but a law firm filed some comments in support of this, just simply saying that they represented a lot of business service organizations, but they didn't say who they were. And then they filed a comments, shortly in January of this year, filed comments saying, we agree and move forward with this rulemaking. We think it's a good idea. And I think there maybe was one other one. Maybe AT&T, Sprint, or somebody might have filed some comments. But other than that, there's been very little formal. There have been a lot of ex parte meetings. I'm sure at every opportunity when people meet with the commissioners or talk to FCC staff, they bring it up. As in terms of formal filings, there have not been a lot of formal responses to this petition for rulemaking. I think it's below the radar for most people.
Okay, and so in the process for filing those comments, is that something we would need legal counsel to do, or is it?
Well, you obviously that's a straight line. Huh? Obviously, legal counsel would be helpful, and I'm certainly willing to help anybody do that, but it's not essential because, again, right now what you're really doing is you're saying to the Commission, we note that this petition for rulemaking is there. We think it's a good idea. It might be helpful to say a sentence or two about who you are and why you think this is an industry concern. But the bottom line, the real message you're taking is, move forward with this petition for rulemaking. We'd like you to start a rulemaking process to receive wider comments on this and to get the ball rolling. I'm looking for, I don't have it here, but I'll find it. And Jay, I'll send it to you and you can circulate it. There's a rulemaking number on this thing, but unfortunately the only document I printed out was the petition for rulemaking itself. So obviously when they filed it, they didn't know what number it was going to get assigned. But there's a rulemaking number, which is RM number and then something. I'll find out what that number is, and that's the number you would want to use in submitting any comments on this. Just so it got, to make sure it got associated with the right place. It's the petition for rulemaking filed by the Alliance for Telecommunications Industry Solutions on August the 17th, 2011, and then there will be a rulemaking number, which I unfortunately don't have handy right now.
And Bob, once let's say that a notice of proposed rulemaking was launched by the FCC, and there's time for comments and so forth. About how long does that process take?
Well, it depends. In recent years, they've gotten faster about the comment cycle. In other words, they've put fairly short times on you. You can see anywhere from 30 days to 90 days or something like that for comments, and a shorter time for reply comments. But the real question then is how long does it take them to do stuff afterwards? But that's only part of the process. First process is getting the notice of proposed rulemaking issued. And then, of course, it's important to then get together and file comments, and that's where you would want to, the people who can afford it, or if they can't afford it, maybe we could pool some resources and get some consulting economic analysis and all the legal arguments and put forward that. But then also it's important for actual people in the industry. We lawyers can certainly help in putting together the comments, making the legal arguments, marshaling consulting experts, and all of that's important. But more important than that, or as important, is that once all that's on file, to also then come in and visit with the commissioners. Certainly visit with the commission staff, but try to get meetings with the commissioners themselves to talk about this. And I got to tell you, it really makes a difference if it's people from the industry. I mean, they hear from us lawyers all the time, and, we're just hired guns. But they are, believe it or not, they are interested in what the actual principals and players in the industry have to think about these things. And so that's also important, to go in and have what they call these ex parte meetings where you sit down and make the pitch. And I think a big advantage you would have in this particular rulemaking is that I could be wrong about this. This may be famous last words, but I don't know that there are any natural enemies to this out there. Most, not all, most of the people on this call are probably from what would be classified as small businesses, but even the bigger companies, the AT&Ts and the other players who make up who are constituent members of Addis and all that, are in favor of this concept. So we would have a situation where I don't think there are going to be very many voices, except somebody inside the FCC who may be wedded to this no transfer policy for some reason. I don't think there's going to be anybody out in the public sector who is going to be saying, no, this is a bad idea. We're going to maybe have some slight disagreements about the fine points. So I don't know. I would like to say it could be a year or less, but that's probably optimistic thinking. But that's what I would aim for. I would aim for figuring that we can get the pleading cycle done in a couple of months, have a round of part of what we're going against now is we got 3, if not 4, new commissioners, and we're also in an election year. So by the time this process got down the road, we might also, depending on what happens in the elections, we could be in a transition administration, or even if not, even when the same administration stays in, people tend to change jobs, the bureaucrats. So, that may slow things down. But optimistically, a year. In reality, it might take a little longer than that from beginning to end. To get an actual rule change, you're probably looking at least a year.
Mm-hmm. And to dovetail on what you said about, potential consensus out there in the ecosystem, the Future Numbering Working Group has spent, I think, 6+ years talking about this issue. Issued a white paper, which has basically been, published and shelved, but, a lot of the snow has been plowed in terms of talking about, what would this look like? There's still a whole bunch of details in people's minds as to how it would work. However, the notion of it is, I would say, more acceptable today than it was 5-6 years ago, when it was absolutely blasphemy to even talk about a market-based allocation method for any kind of, telephone number.
Well,
just to...
It might also be prudent, and I hope I'm not speaking out of school here. It might be prudent to narrow the focus of the FCC discussion at this point. In other words, take this in manageable steps. I mean, my concern, and maybe I'm wrong, and I'm willing to be convinced that I'm wrong here, but if we go into the FCC talking about concepts of what this looked like, mechanisms for how it's going to work, a market allocation process, some sort of a system, then there is going to be not even if there weren't going to be controversy, there would certainly that would get into an area where the FCC is not going to. It's going to take them forever to sort of get their brain around that and what they want. Whereas the Addis proposal as it stands right now doesn't talk about changing the system. It just talks about changing the rules with the current system in place. So if the Addis petition were adopted as rules today, the way it reads, those exceptions certainly give us a lot of breathing room and comfort that we don't have now. And then the discussion can go on about, okay, now that we've got this far, now what do we do about some sort of a market-based system to implement this? Do we create some kind of an exchange? Do we create, whatever? That's something that I think can be, but what I'm saying right now is just within the context of the rules that we've got. When I say something can be done in a year or less, I'm talking about getting some exceptions built into the rules that they exist so that when you go out and do a transaction, you don't have to worry that next thing you know you're going to be getting a fine. I personally would try to leave for later, the question of then what do we tack onto that? Where do we go for the real future in terms of any kind of a system? Do we want to go a step further and have some sort of a market-based allocation, a formal system and all that? I just think if that gets into it at this stage, the FCC will clog down and won't do anything for years. That's just my gut feeling.
Yeah. Well, thank you for, reeling me back in.
Well, no, I mean, I that's just my opinion, and you know what they say about those.
I concur. Yeah. So we're about 10 minutes to the end of the call. I'd like to pause and just open it up for comments and questions among the people that are on the call. So.
Yeah, I had a question about Jackowitz's initial slap on the wrist back in 2007. You'd indicated it was similar behavior. Do you have any specifics as you did the most recent action, involving Bristol Myers? What was the specifics around the 2007 action?
I should know because I think I was actually involved a little bit peripherally at that point, assisting his other lawyers. And all I can tell you that I should have pulled the order and reread it, but it involved I recall that it did involve, I'm pretty sure, pharmaceutical numbers, but it similarly involved a situation where there was some major company who got their nose out of joint and went to the FCC and complained. And this is a story I sometimes hear, without taking any positions one way or the other on either the 2007 case or this one. That's a story I see often where somebody will come to a guy and want to quote unquote buy a number, and they start negotiating, and then the price gets too high, and then the person who initiated it runs to the FCC and complains. It's the old theory about we'll arrest the prostitutes but not the Johns, But anyway, it was a similar kind of a thing. It was a pharmaceutical number situation, as I recall.
All right.
Hello?
Yes. Hello?
I'm sorry, this
Bill.
is Jay. I dropped off. Hi, Bill.
Hi. Is everybody still on the line with us?
It said there were 10 participants when I dialed back in. Did we lose Bob? And
No, I'm here.
Okay.
Oh, there you go.
Okay, good. So
was there
go ahead.
A statute on this? I thought I read in your paper here that there was a year, a statute of limitation on one of these transactions. Is that?
There's a statute of limitations on it's not exactly a statute of limitations. What the FCC cannot do is, if they're going to fine you, they have to fine you within a year of giving you some kind of a notice of the violation. I can't remember how that plays out here, but what they did was, you'll have to go back and look at what I wrote at the time. But generally the rule is that they have to issue you, and I think that what they issued to him here was a notice of apparent liability. And I think the notice of apparent liability has to refer to conduct that occurred within the year. So in other words, it could only go back a year from the time of the notice of apparent liability. But I think they satisfied that here as far as they were concerned. I mean, generally that's what it is. If they're going to issue an NAL, notice of apparent liability, then they're supposed to issue that for violations that occurred within the past year.
Right. They seem to spend quite a bit of time, explaining that and saying that there were
I think
communications. There were communications that went beyond the I think it was July 6th or something like that of 2011, because it seemed like this was issued just almost under the wire.
And that's not unusual. That's not unusual for them to issue them just under the wire. I mean, they like everyone else are screwing around with their deadlines, and then all of a sudden, I don't know what it is about we lawyers, but I don't think the government lawyers are any different. We tend to file things on the very last day a lot of times, so that's not unusual. But also, you get into a little bit of a different area where there's a continuing violation. Then where do you time it from? And also, it probably factors into how they're going to try and multiply out their forfeiture calculations. But in this case, even though it turned out to be a very big forfeiture, they only got him for 1 times the number of numbers that were involved. And as they pointed out in a footnote somewhere, they could have gone a lot further if they wanted to. They could have done that much for each day of a continuing violation, if they'd wanted to.
Bob,
that's not unusual for them to get an NAL out on the last day of a 1-year period.
Is that statute of limitations?
Yes, go ahead.
Does that statute of limitations start on the day that of the violation, or is it when the FCC is made aware of it?
It's from the date of the in other words, if they're going to fine me for wrong conduct, they have to issue a notice of apparent liability within a year of the wrong conduct. Now we're calling it a statute of limitations, but there's actually another statute of limitations as well, and that is these fines are not what is called self-enforcing. If you can, of course, just pay the fine if you acquiesce. But if you don't pay the fine, then what the FCC has to do is they have to go to the Department of Justice to bring a civil court collection action against him. And by the way, if they do that in U.S. District Court, he gets a trial de novo. In other words, he can re-argue the merits to the court, saying, well, this fine isn't right. But that action, starting that civil action in court to collect the fine, has its own statute of limitations. That statute of limitations is 5 years. And interestingly, it's 5 years from the time of the violation, not 5 years from the time when the fine was assessed. So what frequently will happen is by the time they get around to maybe doing that, usually the statute of limitations is already passed. So there's 2 different statutes of limitations. When can they impose the fine? And they can issue the notice of apparent liability, assessing a fine for conduct that happened no more than a year ago. And then, if they have to go and sue to collect on the fine, they have to bring that action, start that action within 5 years of the violation. So they've really got 2 different statute of limitations they're looking at: 1 year to bring the notice and 5 years to collect on it. They almost never bring those actions to collect, by the way.
All right, got it. Thank you.
I'm sorry, what was that, Bob?
They rarely bring actions. Now, on this size of the fine, they might, but I've had several situations over the past years where a $20,000 fine or less was never acted on. In other words, the client did not pay it because he was going to challenge it in court, and the court action never came. So I don't know now with a $240,000 fine, it might be different. I don't know. That might be enough to make it worthwhile for the district attorney to bring an action.
Mm-hmm. All right, we're coming up on the top of the hour. Any other questions? Any comments? Well, Bob, we really appreciate your time and your input and your dedication to the toll-free industry.
I'm glad to be here. What I will do when I hang up, I'll later today I'll dig out that rulemaking number, and Jay, I'll send you a copy of the petition for rulemaking and the number so that you can get that around to people.
Okay, great.
That'd be nice.
Yeah. And so the next Phone Word Forum will be in August. It's always on the last Wednesday of the month, always at 4 p.m. Eastern. I haven't extended an invitation to someone who's an expert in the toll-free broadband realm, and so far I haven't confirmed that. But beyond this particular issue, my personal opinion is toll-free broadband is, in my view, is a much bigger consideration than even something as weighty as this FCC fine. So I think for the foreseeable future, the Phone Word Forum is going to be talking about toll-free broadband, how that might impact legacy toll-free telephone numbers and legacy toll-free telephone, the whole paradigm. So with that, we will say goodbye and look forward to any comments you might have. Thank you.
Thank you.